The committee will come to order. Jcar policy is to allow only representatives of state agencies to testify orally on any rule under consideration at committee hearings. If members of the public wish to express their views with respect to a proposed rulemaking, they should submit written comment to the Jcar office at the following address: Joint Committee on Administrative Rules, 700 Stratton Office Building, Springfield, Illinois, 62706. Attendance roll call, please.
Senator Cunningham.
Here.
Senator Curran. Here. Senator DeWitt. Here. Senator Lightford. Senator Munoz. Senator Rezin. Representative Demmer. Representative Halpin. Here. Representative Hurley. Representative Reich. Here. Representative Tarver. Present. Representative Wheeler. Here. 10 members are present.
Thank you. Quorum is seated. Next, we'll move for approval of the minutes. Senator Lightford moves and Senator Rezin seconds that the minutes of the August 18th, 2021 meeting be approved. All those in favor will say aye. Those opposed say nay. In the opinion of the chair, the ayes have it, and the minutes are approved. Next, we'll review agency rulemaking, starting with the Secretary of State, tab 34, Procedures and Standards, and tab 35, Certificates of Title, Registration of Vehicles. Staff, please read the motion.
Jcar, with the concurrence of the Secretary of State, extend the rulemakings titled Procedures and Standards and Certificates of Title, Registration of Vehicles for an additional 45 days.
Representative Halpin moves, and his motion is seconded by Representative Tarver, that the motion just read be approved. All those in favor say aye. All those opposed say nay. In the opinion of the chair, the ayes have it, and the motion passes. Next, we will deal with agency responses, starting with the Department of Revenue in tab 51, Leveling the Playing Field for Illinois Retail Act. Staff, please read the committee response.
Withdraw the suspension contingent upon and effective with the Department of Revenue filing the agreed modifications.
Representative Hurley moves and Representative Reich seconds that the motion just read be approved. Staff, please read the roll.
Senator Cunningham.
Aye.
Senator Curran. Aye. Senator DeWitt. Senator Lightford. Senator Munoz. Senator Rezin. Representative Demmer. Representative Halpin. Yes. Representative Hurley. Representative Reich. Representative Tarver. Yes. Representative Wheeler.
Yes. 10 members voting in the affirmative, 0 voting no. The motion passes and the suspension is lifted. Next, we will move to the Department of Financial and Professional Regulation, tab 52, the Cannabis Regulation and Tax Act. Staff, please read the committee's response.
Withdraw the suspension contingent upon and effective with the Department of Financial and Professional Regulation filing the agreed modifications.
Senator DeWitt moves and Representative Wheeler seconds that the motion just read be approved. Staff, please take the roll.
Senator Cunningham.
Aye.
Senator Curran. Aye. Senator DeWitt. Yes. Senator Lightford. Senator Munoz. Senator Rezin. Representative Demmer. Representative Halpin. Yes. Representative Hurley. Yes. Representative Reich. Yes. Representative Tarver. Yes. Representative Wheeler.
Yes. 10 members having voted in the affirmative, 0 voting no. The motion passes and the suspension is lifted. Next, we're going to move on to consideration of other rulemaking issues. We're going to take up tab number 48, Department of Public Health rule. Representative Halpin has some questions. If we could have a member of the department, please come to the witness table and identify yourself for the record.
Good morning, Justin DeWitt. I'm the Chief of Staff at IDPH.
Good morning, Justin. I appreciate you being here. So tab 48 are the emergency rulemakings, I guess a renewal of the emergency rulemakings for nursing homes and intermediate care facilities. Is that correct?
Yes, that's correct.
To your knowledge, are there any changes from what in this set of emergency rules from the one previously adopted or the one before that?
I don't believe so, other than perhaps dates or technical changes. This is required as the emergency rule previously expired on the 18th, and we're waiting for the Long-Term Care Advisory Board to act, so we needed to renew the rule.
Has there been any consideration been given to revising or refining some of these emergency rules for these facilities, given the knowledge and data we now have about vaccinations and how that affects transmission and severity of illness?
Sure, the department's constantly evaluating the emergency rules and our regular rules to ensure that it is they're in keeping with the most current information we have about vaccination rates, case rates, and we'll continue to do that. For this particular rulemaking, again, we felt like we needed to get the emergency rule back in place, but are committed to continually looking at those and making them as minimally stringent as possible.
Thanks. And the reason I bring it up is our vaccination rates, especially among residents of these facilities, are actually pretty high, and justifiably so. And I think our staff, at least in the homes near me locally, those vaccination rates are increasing as well. And I think in the past, I've certainly been a strong supporter of the administration when it comes to following the science on these restrictions and mitigations. But as I mentioned, we have seen that the data shows if you are vaccinated, the risk of transmission and severity of the illness is significantly reduced. It doesn't exclude it completely, of course, but it is significantly reduced. And so I think at least in some of my local homes, we are finding it difficult to strike a balance between preventing outbreaks and the severity of outbreaks, but also avoiding the continued isolation of our seniors in some of these homes. I think it was certainly justifiable at the beginning of this pandemic, especially prior to the vaccine, that we cut off all family visitation if there's an outbreak and make sure that the disease isn't spreading further in the community. But at this point, if the risks are significantly lower, I think it may be worth considering changing some of those absolute mitigations, perhaps dependent on the vaccination rate of the facility among residents and staff. The other thing I would raise is that not just the family visitation procedures, the isolation procedures, the lack of group activities, but also the testing protocols among nursing homes that have high vaccination rates among staff and residents, I would suggest maybe revisited, because there are some facilities throughout the state that may have to close their doors just because they simply can't afford those stringent requirements, especially if they're only having outbreaks of only one or two residents, and it turns out that's as far as it goes because because they are doing the right thing when it comes to vaccinations and their other protocols. So I just strongly urge Department of Public Health, as this rule presumably comes up again in 150 days, to really look at those issues and see if there are ways that we can more use a scalpel instead of an axe with these facilities. So I appreciate your time today. Thank you for answering the questions.
And we appreciate your input. We'll do that. Thank you.
Any further discussion? Seeing none, in addition to having the Department of Public Health here, we also have representatives from the State Board of Education. We'd like to ask them to come to the witness table right now for discussion on matters that are important to several committee members related to questions whether or not the department has promulgated policy outside of rule. I don't know if anyone from, we ask the Representative Isby here to identify themselves, if you don't mind doing that for the record. And then if you do have an opening statement, go ahead and offer it. If not, we'll go to the committee members for questions.
Sure. I'm Jennifer Saba, Executive Director for Regional Services with the Illinois State Board of Education.
Good afternoon. Jeff Aronowski. I'm the Executive Director for Safe and Healthy Climate at the State Board of Education.
Again, Justin DeWitt, Chief of Staff at IDPH. I'm here to assist ISB in answering any questions related to testing and vaccination.
Hi, I'm Kirsten Kennedy. I'm a Deputy Legal Officer with the State Board of Education.
Okay, if you don't have a statement to offer, we'd open it up to questions from panel members. Senator DeWitt.
Thank you very much, Mr. Chairman. Welcome, everyone. I do have a brief statement, and I will make it brief, sir. First of all, I want to thank representatives from ISB and the Department of Health for being here today. To begin with, I want to reiterate that as members of this bipartisan and bicameral Committee on Administrative Rules, I believe it is our job to oversee the rulemaking process by state agencies, making sure they abide by the original intent of legislation, or in this case, what appears to be a mandate handed down by the administration. It is important to get into the record that just because we are questioning ISB's authority to take financially punitive steps against school districts that choose to exercise local control with regards to the mask issue, it does not mean we don't recognize the benefit that masks provide. Personally, I have no issues wearing a mask. It's how I can protect myself and those around me. I was also vaccinated as soon as the vaccine was readily available to my age group, and I have encouraged others to also get vaccinated, as it is evidenced by 2 vaccine clinics I hosted in my district in partnership with the Illinois Department of Health. Having said that, I do have concerns with government overreach and those who act outside their authority. That is the purpose of our questions today. As one member of Jcar, it is incumbent upon all of us to ask questions to ensure government is acting within its authority and in line with state statute. The focus of our questioning today centers around this primary issue. Does ISB have the authority, simply under a governor's executive order, to enforce a mandate for funding without legislative cause? And does the heavy hand of state government have the legislative authority to dictate rules or regulations for private schools? Specifically, under what authority does ISB believe they have the ability to restrict funding to school districts that choose not to abide by the mask mandate? I would like to see the statute that grants ISB this authority. To the best of my knowledge, I don't believe that authority exists. When a House representative files legislation after the fact that does give ISB that authority, in my view, it is a veiled admission that perhaps ISB had stepped beyond its authority. And by the way, I find it very interesting that the bill was filed, yet not heard or voted on, even though the House was in session last week and could have very well considered this legislation. I look forward to hearing from representatives from ISB so we can all gain clarity on this issue. Thank you, Mr. Chairman.
Senator DeWitt, did you want to address specific questions with
I
members?
think other
or-
members have questions they'd like
Okay.
to slide
Senator
right in,
Curran?
Mr. Chairman, if you would.
Thank you, Mr. Chairman. Thank you to the members of ISB and IDPH for appearing today. First, let me start. The committee promulgated 2 questions in advance that were sent to you, and we have not received a response yet. Question number 1, does the board plan to file administrative rules to implement EO 2021-18 or the revised public health guidance for schools supporting the full return to in-person learning for all students? If plans are in motion, then when should this committee expect to see a rulemaking? If plans are not in motion, then please aid the committee in understanding the board's legal reasoning for not filing administrative rules. Under the Illinois Administrative Procedures Act, a rule means each agency statement of general applicability that implements, applies, interprets, or prescribes law or policy. And all rules of agencies shall be adopted in accordance with Article 5 of the Act.
Hi, Senator. ISB does not currently plan on filing rules. ISB is relying on the court's decision in Hudsonville So that was a case that was decided last year. The final order came out in December of 2020. And the court in Hudsonville found that the governor's executive orders requiring schools to comply with certain health measures associated with in-person instruction, including requiring face coverings at schools, and guidance issued jointly by ISB and IDPH detailing those measures were lawfully issued and enforceable. Further, the court found the governor's executive order and IDPH ISB guidance were lawfully issued both statutorily and constitutionally.
In 2020 and 2021, the Department of Public Health implemented face covering policies in public spaces, businesses, and schools that were authorized and reauthorized by various executive orders through emergency rulemaking. If administrative rule will not be filed to implement Executive Order 2021-18, then please explain the board's authority to implement and enforce face covering policies in schools authorized by executive order without administrative rules and the legal reasoning for departing from the precedent set by the Department of Public Health, which did in fact follow rulemaking, the rulemaking process and issued an emergency rule.
So I can't speak for IDPH there, but as it relates to ISB, again, ISB is relying on the court's decision in Hudsonville. ISB is doing as it has been directed to in Executive Order 2021-18, which was reissued by 2021-19. That executive order requires ISB to issue joint guidance. This follows the past precedents as it relates to ISB, as that is what was required under ISB under the prior EOs and joint guidance that was subject of the Hudsonville case.
So I want to talk specifically about, I think, the first instance of non-recognition status or recognition being revoked that I'm aware of, and that was Timothy Christian School and the timeline on that. Now, in the administrative rules, Title 23, Section 1.20, it has the process for recognition status as well as revocation of recognition status. My understanding of the timeline with Timothy Christian, the governor issued Executive Order 2021-18 on August 4, 2021. The superintendent of Timothy Christian posted a video on August 11 of 2021. And immediately that, indicating that they would make masking optional and a parental choice. And immediately that same day, that school was notified in a letter, according to the Chicago Tribune. Let me get the quote here. That its recognition status was being immediately revoked because it declined to affirm it would comply with Executive Order 2021. So a determination of revocation made the same day. When I look at the process in the administrative rule, it states the step-by-step process for how a school becomes non-recognized is first the school is placed on probation. Were the Timothy Christian schools placed on probation?
No, sir, they were not. Non-public school recognition is dealt with in Part 425 of the rules. Part 1 is public school recognition. Non-public school recognition follows a different regulatory process than public school recognition. The non-public recognition process allows for immediate non-recognition without a probationary period in instances in which the state superintendent determines there's an emergency situation present at the school. And that's pursuant to 23 IL Admin Code 425.60.
What due process was Timothy Christian afforded in a decision that was made the same day to pull the recognition status?
So ISB has a few pending lawsuits against it related to masking, including the enforcement, and we are unable to answer certain questions related to the pending litigation.
is the lack of due process or an allegation of a lack of due process for those school districts or being afforded to those school districts, is that a subject of any of the pending litigation?
I would need to review it, but I believe it may be.
Well, I would say it's not surprising that that is, you're now dragged into court again, because this, on its face, is a very heavy-handed tactic that does not afford any due process. You have a process in the rule under section 1.20 that lays out a due process timeline that allows for meaningful discourse between a school district and the department, and really it also allows cooler heads to prevail, which is, I think, part of why you have some time markers in a process. I would certainly encourage the department, and quite frankly ask the department, in making these decisions, they should be following 1.20, whether a school is private or public. You should have due process in place for all schools, all parents who are invested in these schools, whether public or private, and most importantly, the children that attend. And the process that's in the code, in the rule, and I understand your point, you're saying it doesn't apply to a certain subset of schools, seems to be a lot more thoughtful than how the department has gone about handling this situation, which has caused spillover into the courts and, quite frankly, a lot of hostility amongst parents and school administration. So with that, I would turn it over, Mr. Chairman.
Thank you. Representative Reich.
Thank you, Mr. Chairman. Thank you for coming today and answering our questions. I appreciate it. The question, I've got a question specifically to the Hudsonville case. Can you give me a synopsis of the ruling in Hudsonville, please? Excuse me.
The court, so it had to do last year with similarly issued executive orders, and those executive orders directed ISB and IDPH to release joint guidance related to certain health measures associated with in-person instruction, which included the requirement of face coverings. So the court found in that case that the governor's executive orders requiring schools to comply with certain health measures associated with in-person instruction and the guidance issued jointly by ISB and IDPH detailing those measures were lawfully issued and enforceable. And the court also found that the governor's executive order and IDPH ISB guidance were lawfully issued both statutorily and constitutionally.
Okay, okay, fine, thank you. But did the Hudsonville court extend that ruling to the enforcement by virtue of non-recognition and withholding of funds to the schools that chose not to comply?
I do not believe that was an issue in that case.
So that is an issue that is still on the table. So what I'm asking you, I guess, is if you're relying on Hudsonville for the purpose of justifying the actions of ISB to take this action, where do you go to make it further, to give ISB further authority to enforce through non-recognition and withholding of state funds?
So ISB has authority under the existing rules. So 23 IL Admin Code Section 1 for public schools and 23 IL Admin Code Section 425 for non-public schools. And that's the existing rule in which ISB is using for enforcement.
Is non-recognition and withholding of state funds, is that encompassed within the parameters of that rule?
Yes, we believe it is.
We believe it is.
It is the subject of pending litigation right now, so I'm not able to say any more further on that.
So the reasonable people can disagree. Thank you.
Senator Rezin?
Thank you, Mr. Chairman. Along that same line of questioning, is it your intent to use this approach for all public school or private schools that choose to go a different route currently or in the future?
ISB has been using its authority under the Illinois administrative rules related to non-recognition, and I believe ISB, that is the current path.
So what I heard you say is that ISB will continue to use this approach in handling the issue with the private schools.
Yes, we are working with, ISB's main goal is to get all of the districts in compliance with the current mask mandate.
And I understand that. And again, we're not here to have a debate on mask mandates. We're here to understand if ISB has overreached with their authority. And I know that you continue to cite that there's a court case, so obviously there are people that believe that you have overreached your authority. My colleague talked about his concern for lack of due process. And I know that you're citing different statute for the public schools versus private schools. But again, it's very difficult to explain why they're treated differently in this situation and why there isn't due process, especially in this circumstance for the private schools. Do you plan on filing any kind of emergency rule to clarify this, or do you feel at this moment that the statute that you have cited is sufficient to allow ISB to determine whether a school or whether they can withdraw their recognition status or not and withhold their funds?
I am not aware of any plans to file emergency rules related to this.
Okay. Thank you.
Co-Chair Wheeler.
Thank you, Mr. Chairman. And thank you all for being here. I know it's a lot to go through here. I got a question regarding the executive order, but more importantly, the court case that you had cited just a moment ago, and you've referenced a few times during questioning. You refer to guidance during that particular interchange with, I think, Representative Reich. Is there a difference between guidance and rule?
I think the process, there's a difference in the process, but ISB was directed in the executive orders to issue joint guidance in the executive orders.
But guidance is guidance. Guidance is not a rule. A rule is enforceable. A statute is enforceable. I don't believe that an executive order is enforceable to the same degree statute and rule are. So I want to understand how your agency is seeing rulemaking versus guidance.
Again, we're relying on the court's decision in Hudsonville that found that the executive order, along with the joint guidance by ISB and IDPH, was lawfully issued and enforceable, and that it was lawfully issued both statutorily and constitutionally.
So now what you're effectively saying is that every citizen in Illinois is subject to guidance at the same level that they are to rule. And there's a difference between those two things. There's a different process for both of those things. There's an oversight process that you're sitting here in the middle of regarding rulemaking. There is no such oversight process for guidance. So how is the public protected from government overreach if we're going to make them all live by guidance alone and not by rule?
So again, this is the subject of pending litigation. All I can say is that ISB is relying on the court's decision in Hudsonville, and that is specific to health measures associated with in-person instruction, which includes requiring face coverings at schools and joint guidance related to that, along with the executive order requiring it.
Okay, I'm going to go back to the fact that how you enforce something that is guidance, to me, goes beyond every part of the administrative code. I looked at the particular reference you made to IAC section 425.60 regarding changes in recognition status, and I guess I don't see where it says that the State Board of Education can arbitrarily choose what measures will now be set for compliance, so that the state superintendent can at any time, change the recognition status. What changed in the Illinois Administrative, if you're relying on the Illinois Administrative Code to change the recognition status of these different schools, what else changed in the Administrative Code to allow you to do that? I don't see a statutory authority anywhere else in the IAC that lets you change it based on something that arbitrarily was chosen by either executive order or by the department to affect that authority. I don't see it in the statute. I want to see something specific to that so that I'm comfortable with the fact that we're following the process as the IAC affords us.
ISB has been utilizing 23 Ill Admin Code 1.2 B2A with public schools, which establishes the recognition process for public schools. A school district shall be placed on probation if it exhibits deficiencies that present a health hazard or a danger to students or staff. We will continue to act swiftly with both non-public schools and public schools that have confirmed they are not implementing universal indoor masking. As required by Executive Order 2021-18, ISB will not compromise students' health and safety. Masking is a safe, easy, and effective way to ensure all students can attend school in person this fall, where they can learn and grow to their fullest potential.
I'm sorry, where are you reading that from? From where? From what part of the IAC are you reading that?
So the 23 Ill Admin Code 1.2 B2A is a school district shall be placed on probation if it exhibits deficiencies that present a health hazard or a danger to students or staff. So that is in current administrative code.
Okay, and you're just saying you're applying it based on words that were given in the executive order.
Yes, based on the executive order.
But you couldn't have put that in rulemaking.
In the guidance.
Why wouldn't that be appropriate to put into emergency rulemaking?
ISB is complying with the executive order, which directed ISB to issue joint guidance with IDPH related to that executive order.
I think that very same executive order also referred to rulemaking as something that could have been done. Why wouldn't that be the most appropriate place to put this measure?
We can offer a response. I just wanted to make, I didn't know if you were going to respond to something that.
No, I was trying to look at the executive order, but we can, if we could have time to look at that and maybe provide a response on that. But I think it's.
Yeah, let's go on to other questions first, and then maybe during a recess, potentially, we can review that.
Okay, thank you. Representative Halpin.
Thank you, Chair. I first just wanted to address something that one of my colleagues had mentioned. Obviously, I've gotten a lot of email from constituents on both sides of the policy issue. But without getting into the policy itself, one of the arguments is raised is that a bill had been filed, 4135 in the House, that would specifically grant this authority to ISB. And I think the argument that was made was that this must mean that current law doesn't allow it. And I just wanted to clarify that that's not always what a bill means. In fact, there is a bill filed by another one of our colleagues, House Bill 4803, which specifically prohibits ISB from implementing this type of policy. And by using the same logic, that must mean that the sponsor of that bill believes that the ISB does already have that authority and therefore wants to prohibit it. So I want to focus the discussion not about pending legislation, because neither of those bills has been called or voted upon, and just really get to the heart of what ISB is relying on for executing this authority. And I think I heard the question may have already been asked just now and answered just now, but you are relying at least on existing rule when it comes to enforcement of the policy with respect to recognition and funding. Is that correct?
Yes, Representative.
And then connecting the executive order to that existing rule. So the executive order identifies a health threat and issues and directs the agencies to issue guidance, correct? And that it's my understanding, based on your testimony, that that's essentially what also happened in the Hudsonville case, where the executive order directed the agencies to issue guidance, and the authority to issue the guidance was upheld. Is that right?
Yes, sir.
And so then here, I think the argument that ISB is making is that the authority is granted in the executive order to cover this subject matter. ISB already has the authority under the existing rules to withhold recognition based on health risks. And that's essentially the connection that you're making. And in this case, is that right?
Yes.
And that's where the argument that we don't need additional rules because we already have the authority in existing rule. Is that fair?
And in the court's ruling in the Hudsonville case.
Right. When you train those together, then you have the authority. Okay. I just want to get a kind of clarify and distill what that argument was. Thank you.
Chair Wheeler?
Thank you. I just want to go back to the difference between guidance and rule. If we rewind back to last year, there was a point in time when an executive order was posted that my friends in the Department of Public Health followed up eventually with emergency rulemaking. They did it for a reason. The executive order really had no teeth. You can't just say, you need to do this because the governor says so. There has to be something that goes along with that to make it enforceable. And we went through lots of iterations and hours of discussions trying to land on something that was better than what we started with, and I think we actually did that last year. But it was all done by emergency rulemaking. When it comes to how we direct things toward the public, guidance says should, and rule and law say shall. And rarely can you cross over those two, because otherwise there's no point in us having a legislature to oversee these things, to set the policy. Our job in the legislature is to in Jcar in this case, is to oversee what's done there to make sure that it has legislative intent behind it, that it meets those same criteria, that we're protecting the public from arbitrary application of, in this case, guidance. And I believe that I know you've referenced this 425.60 a few times. All that is the mechanism by which you can say we're changing the recognition. You're not talking anything other than guidance about what the thresholds are to change that. That can be done and should be done by rule, not by executive order and not by guidance issued by an agency. Those are things that affect the general public. That goes before the legislature. That's the process we've chosen in this state so that we have a balance and a separation of powers. We're not having that here, in my opinion. And what you referenced me so far is a court case that says the executive orders can hold up under any circumstance. Actually frightens me a little, because that means any agency can take that to any level they want to. I have real concerns about that. We have an oversight responsibility in this committee to look at policy outside of rule. And by everything you've said so far, this is clearly policy outside of rule. Thank you, Mr. Chairman.
Any other questions? Okay, I have one, Ms. Kennedy. So you said that the department does not intend to to promulgate any emergency rules related to the mask issue. Is that correct?
Yes, sir.
Do you plan to promulgate emergency rules related to any other part of the governor's executive order?
which executive order, 2021-18?
Yes. No.
Not that I'm aware of.
Okay. All right. Okay, the committee's going to take a brief recess. The committee shall come back to order. Thank you all for your indulgence while we conferred with each other for a few minutes there. I believe we're going to entertain a motion in reference to the discussion we had with ISB. I'm going to ask staff to read that motion.
There is a concern that policy outside of rule may exist, and Jcar encourage ISB to place all policy and guidance in rule. Jcar recommends that ISB provide an update to the committee within 30 days. Additionally, Jcar recommend that ISB propose additional amendments to 23 Illinois Admin Code Part 425, expanding and clarifying the school recognition status to include a better defined process prior to the revocation of recognition.
Representative Wheeler moves and Representative Halpin seconds that the motion just read be approved. Staff, please take the roll.
Senator Cunningham?
Aye.
Senator Curran?
Aye.
Senator DeWitt? Senator Lightford? Senator Munoz? Senator Rezin? Representative Demmer? Representative Halpin? Representative Hurley? Representative Reich? Representative Tarver? Representative Wheeler?
Yes.
By a vote of 10-0, the motion carries. Now we'll move to the certification of no objection. Please note that the Illinois Gaming Board's tab 8 is postponed to the October meeting. Staff, please read the certification motion.
The committee shall inform the agencies to whose rulemakings the committee has not voted an objection or extension or did not remove from the no objection list that the committee considered their respective rulemakings at the monthly meeting and, based upon agreements for modification of the rulemaking made by the agency, no objections will be issued.
Representative Hurley moves and Senator Lightford seconds that the certification motion just read be approved. All those in favor say aye. All those opposed say nay. In the opinion of the chair, the ayes have it, and the motion passes. Jcar's next meeting will be Tuesday, October 19th, 2021, in room C1 of the Stratton Office Building at 10:30 a.m. in Springfield. With that, Senator Lightford moves and Representative Halpin seconds that we adjourn. In the opinion of the chairs, the ayes have it, and this meeting is adjourned.